In this video, we would like to discuss the legal effects or the consequences of divorce under the Dissolution of Muslim Marriage Act 1939. So, the first legal effect or consequences of divorce is that right to contract another marriage, and if consummated, then after a period of iddah, and if not consummated, then immediately. So, if it is consummated, then the wife have to observe the period of iddah, or if it is not consummated, then she has the right to marry immediately. Then, in case of death of the husband, only after the completion of the period of iddah. So, this is the first legal effect or consequences of any divorce that was obtained or that is obtained under the Dissolution of Muslim Marriage Act. And the second one is relating to the claims, that is right to dower or meher. So in case of that, if the marriage is consummated, dower becomes immediately payable, and if not consummated, then half of the dower or meher would be given to the wife. If it is not specified in the talaknama or nikahnaama, then only 3 articles of dress would be given by the husband after the divorce under judicial process as provided under the Dissolution of Muslim Marriage Act. And the third one is relating to rights of inheritance. So the legal effects relating to right to inheritance in irrevocable divorce, mutual rights of inheritance suggests immediately, but when divorce pronounced during husband's death or illness, then it suggests only after the period of iddat observed by the wife. And the number 4 is that the position regarding cohabitation. So, the irrevocable divorce there in cohabitation becomes unlawful, and those offsprings out of that cohabitation would be considered as illegitimate. And the fifth legal effects of any divorce under triple talaq, that is also falling under the legal effects of dissolution of marriage under Muslims Act 1939. Remarriage of divorced couple when it is with a triple pronouncement, then an intermediate marriage, and a subsequent only after actual consummation with that husband. In all other forms of divorce, remarriage may be done during iddat or after its completion. In the leading case, Ghazni Bibi and Ghulam Dastagir in 1968. The Mysore High Court expressed pronouncement of talaq is sufficient. The intention of the husband is inconsequential. Statement in the court by the husband can be declared as divorce, as it was observed and decided in the case of Abdul Ali versus Raise Begum in 1988 by the Rajasthan High Court, and in Jinnat Fatima versus Iqbal Anwar in 1995. The Assam High Court mentioned words of divorce must indicate intention to dissolve the marriage. And our next leading case is regarding Begum Bibi versus Abdul Razak Khan, and it was a case of 1995. The Odisha High Court observed that filing a written statement in defense to a maintenance claim is enough evidence of divorce. So, our next leading case is the very important case, that is Dilshad Masood versus Ghulam Mustafa, and it was a case of 1986, and it was decided by the Jammu Kashmir High Court in 1986. So here the statement before magistrate or in writing without following the requirements of Sharia law, the divorce is not valid as expressed by their lordship in their delivery of judgment in 1986 in that leading case Dilshad Masood versus Ghulam Mustafa. So, these are the legal effects or consequences of a divorce, either obtained or it would been decided by the court of law under the Dissolution of Muslim Marriage Act 1939. So, in our next video, we would like to discuss regarding the very provisions of maintenance and those maintenance as provided under the Muslim Women Protection of Rights on Divorce Act 1986, also with decided cases. So, regarding the legal effects or consequences of divorce, that the consequences we had discussed. One is right to contract another marriage, and that also under what circumstances and what are the prohibitions when to right to contract another marriage arises as one of the legal effects or consequences of divorce. Then, regarding the very claim of a divorced wife, as regarding to her right to claim dower or meher, as it was fixed during the nikah or nikanama, so also the very right of inheritance of both the husband and wife in relation to their movable or immovable properties after they are being legally separated or divorced. And the fourth one is relating to the position regarding cohabitation. So, after divorce, under what circumstances and how the Islamic law, so also the dissolution of Muslim Marriage Act 1939 provided the cohabitation between the spouses and regarding observing the period of iddat, so also in case of death. So, after that, the question arises regarding remarriage, and that remarriage only after triple talaq. So, after triple talaq, how a remarriage of a divorced wife, so also a male who divorced his previous wife could be possible. So, these legal effects we have discussed, and regarding that, we have discussed certain important leading cases like Ghansi Bibi, Ghulam Dastagir, and it was decided in 1968. So, also Abdul Ali versus Raise Begum in 1988, and Jinat Fatima versus Iqbal Anwar in 1995. Then the fourth important leading case is relating to Begum Bibi and Abdul Razak Khan in 1995. And the last important leading case, and that is Dilsad Masood versus Ghulam Mustafa, and that was in 1986 decided by the Jammu Kashmir High Court. So, in our next video, we would like to discuss regarding the position of maintenance as provided under traditional Islamic law, so also under the present act. So, before ending the video, I would like to request all my viewers to please like and share my videos, and please kindly subscribe my channel, which is DP Law Classes.